or otherwise it's going to be pitched. So this here, I think, is a great way to help yourself. I also tell clients that come in, lawyers that come in to me that want to sue clients, did you send a termination letter? No, I did not. I don't have to. Well, before you want to sue your client for that $60,000 fee, let's send him a termination letter, identify end of the case, a letter from the client terminating it. Let's identify when that termination occurred. And if you didn't have anything that's openly obvious to terminate that, let's send them a letter terminating it now and file suit a year and a month later. Because they cross-claim all the time. That doesn't mean you're still going to get your fees, but you don't have a legal malpractice action. And it's really easy to get out of. It's because you just hold up the letter and say, you're barred. And judges pretty much, unless there's something by fraud that's going on, a wrong address, a certified mail problem, email issue, bounce back, you're going to get it. So I highly suggest, I do this on every single file. I send a closure letter out, making sure that the client knows the case is over and I'm done. This article from this month's Ohio Lawyer Magazine is a really good article. I don't know the individuals here who went ahead and prepared it, but when reading it, I thought this was an excellent scope here. Some of the cases that we talked about, and that's that one I cited earlier. Which one was that? Dealt with, here it is, Daniel versus McKinney, dealt with when was the case terminated. Now, was it terminated when he files a motion to withdraw in a case? Suppose the client gave him a letter, said you're fired. Then he files a motion. Is he still the lawyer till the court tells him he's not the lawyer anymore? I know this much. In federal court sometimes the judges have told me no, unless there's a substitution of counsel. And that, while it's not a warm and fuzzy feeling, if you think your case is terminated as of that date, no, it may not be. So it's a fact-specific, as the Daniel case talks about. It looks into where are we going with this. If, in this case, Daniel sent a letter, said you're terminated. Court said, well, that's pretty good for us. But needless to say, then he filed a motion to withdraw. And different facts may be in different cases. So just be careful. Just filing a motion to withdraw and firing the client isn't good enough. And if you withdraw, that's different. For example, if you lose in a trial, jury trial, bench trial, I don't care which it is, are you still that guy's lawyer up until the appellate period runs? Don't you have an ongoing duty? Absolutely, no doubt in my mind. So you have the duty to inform them of what their post-judgment rights are, whether that be motion to set aside a trial, motion for relief from judgment, whatever the circumstances dictate. But you're not going to be able to terminate that relationship unless somebody substitute by a unilateral document, unless you can get it court ordered. That's different. But a lot of courts, like probate court, they're not going to let you off very easily. I know federal court does not. Bankruptcy court does not. In Chapter 13s or Chapter 11s, you're stuck. I've had judges just tell me, get a bigger retainer up front if you're not paid, literally. So the next one is you start off with, of course, a claim. If you don't have the opportunity to get a demand out ahead of time, often I have gone ahead and filed a complaint once service is effectuated, once an answer is filed, seeing whether or not they're objecting to the insufficiency of service or not. And if they do, I call them up and say, I have a process server that served your guy. What's your basis for that? Are you really pursuing this? Or is this something that I can dismiss the case to investigate it and go forward and get in writing from the defense lawyer? Okay, we shotgunned our defenses. That's not really a defense that has merit. And now you dismiss 41A. Now you got a year. Now you don't have to be under the throes of discovery, of a judge's temperament on your case. Now you can begin to do your job to do what? What you didn't have time to do before you filed the lawsuit. And that is get together, get your witnesses and experts together, present a demand, try and settle it. Again, it's a lot cheaper than going through the trial. You have to get the attorney's file who was in the underlying action. First thing, you have to get your own client's file and the attorney's file. Immediately bait stamp them. Immediately scan them. They're going to ask for that file back. Many attorney will go ahead and give the client, which is their right under the rules, the original file. and I got my door knocked on many a time, give it back. I give them a copy back, but the bottom line is the client's file. It's not the lawyer's file. The lawyer's entitled to a copy of it, without charge, by the way. So make sure you get that out. Make sure you send out who are your witnesses. I do it as soon as the answer is filed, every case. I don't care whether it's a divorce. I don't care whether it's the simplest little civil action I got. I send out interrogatories and production documents. Who are your witnesses? Lay or expert. What are your exhibits that you're going to use at any hearing or trial? As simple as that, because why? There's a duty to supplement. So immediately I'm trying to define who the players are in the arena to be able to know who do I got to go after. In a malpractice case, it is huge to find out if there's insurance involved. I think it's 26, I want to say A, there's a provision that you can demand for an insurance policy to be delivered covering whatever actions of the defendant there are, or co-defendants if there are. I send that out with my discovery interrogatories once the answer is filed, a demand for insurance. I ask for it in the interrogatories and I ask for it separately. I always get it. That way I know now what am I playing with. She brought up a very good point. In the case that we had $480,000 damages in that dopo when the guy died at 55 years old, and my client's expected lifetime was going to be, what, 78 or 79? So she lost huge, $100,000 policy. We all just sunk in our chairs the day I got that. It was like, oh no, I got excellent liability, and here I got a $100,000 policy. Well, that's going to change your strategy on that case, I guarantee you, because now you got to think what she brought up before. How much do you spend? How much do you go through? Trials are not fun for clients. They may be fun for somebody like me, but they're not fun for clients. You got to be careful and let them know that. I oftentimes will send out requests for admissions on key documents that I get. I don't want to fiddle with stipulations later on. Send it out at the beginning of the case. Now you know what you got and you can rely upon. And by the way, your expert can rely upon to give valid and good opinions. Of course, take depositions. I could think of one case. Matter of fact, it was that elbow case. I didn't take the deposition of the doctor. That was just too easy of a case. I had a Yale doc on the other side, on my side, and that case settled pretty quick. But the fact is, get the depositions of the parties as quickly as possible. I wait till I get the interrogatories back and get the production done, but then immediately try and get their deposition, because their testimony is going to change as they get discovery from you. Guarantee it. That's the old idol. John and I always laugh. What are the best answers in a deposition that you tell your client? Yes, no, I don't know, I don't remember. That's going to happen later on in the case more than it's going to happen at the beginning of the case. So if you need to get those depositions done, get them done early. Try to get your experts prepared. I actually will drive. I'm going up to, lucky me, I'm a Marquette fan, so I go up to watch the Big East, but I got a doctor in New York City, and I'm going to make sure I spend time with him on this case I have. It's a rather large case. To sit down across the table from him, look him in the eye, try and make a determination, how's he going to come across to the jury? There's nothing worse than you travel out to, I did this case, travel out to Philadelphia. I looked at this doctor, he sounded great on paper, sounded great. He was disheveled and just immediately I was like, oh my God, he's gonna make a terrible witness. You know, he didn't speak very well, he would stutter and stop, he wouldn't look at you, and I'm like, oh boy, oh boy, oh boy. Take the time to look at your experts, sit down with your experts, develop a relationship and a synergy with those experts. They are your case. While you are the one providing the theatrical show, they're the ones that everybody's going to listen to. And I've had time and time again jurors come back and say, oh, well, I just took whatever that expert said and whatever that expert said, and I didn't listen to any of it. I listened to here, there, or otherwise. Well, it's your job to make sure your expert is more believable and is accepted by that jury, because that's a dangerous situation to be in when you hear that they didn't even listen to the people that are telling them what's wrong in a particular case. The damages case, we talked about the Merkel decision, and that decision I've attached for you as well. There's a serious automobile accident, loss of consortium. They end up having huge damages for everybody involved, but one's a minor. Then they go to probate court. Well, the family worked out a little bit of deal, and the lawyer said, don't worry, I go off with the judge. I can get this deal passed through where the minor's going to have a paltry amount. I'm talking $9 million judgments, okay? So bottom line is they go into probate court and ask for $5,000 or something like this. Probate court denied it. So then a new lawyer gets hired. The new lawyer then goes ahead and asks for something like I think he asked for like $500,000, and then the court recommended $263,000, and then the guardian ad litem. Everybody started arguing about everything, and what it ended up was the probate court accepted the $263,000, but dismissed the case by these people suing the lawyer who tried to do the $5,000, saying you could not control lawyer who had the golf and buddy job. You couldn't control what that probate court was going to do. The court had to do it, and the client knew that. So you can suggest whatever you want to. It's your experience, but that's too speculative to be able to say, I can control the amount that the probate court's going to do. That's the adjudication function of the court. It's not his. The Supreme Court dismissed. And that was, by the way, after trial court, after Court of Appeals. Supreme Court said no. Matter of fact, dismissed all the rest of the things they had. They had emotional dismiss and negligent infliction of anxiety, and court dismissed everything after the trial court had awarded a substantial verdict of like $314,000 or something like that. So, and what they did was they did that on the basis of proximate cause. It wasn't related to the negligence of the attorney. They wrote, since Housel, the attorney, was not the judge, he did not control the probate proceedings. There's absolutely no evidence in the record that Housel's alleged negligence proximately caused any damages to the Merkles, wherever you pronounce their name. The argument is purely speculative.